Hi there, this is Jonathan Ginsberg, and I want to talk to you today about dismissing a Chapter 7 case. Sometimes I have people that come to me, they filed Chapter 7 either on their own or with another lawyer. They've changed their mind and they want to dismiss. And they say, well, can I just dismiss? I've changed my mind and undo what I've already done. And the answer to that is no. Bankruptcy, Chapter 7 bankruptcy is a little bit unusual in that when you file bankruptcy, you cannot voluntarily dismiss it. You have to have court permission to do so. And the reason for that is that the Bankruptcy Code does not want to see people filing bankruptcy to stop a legal action and then turning around and dismissing it and sort of manipulating creditors, if you will, manipulating the system. So the problem usually arises in situations where you have a lot of equity. And again, the best way to explain this is to give you an example. Years ago, and this is probably 20 years ago, I got a call from a fellow who had filed a bankruptcy at Chapter 7 because his wages were about to be garnished. And he filed it as a front page filing, didn't put any information in there, but basically said, I want to dismiss it. And it turns out that in his case, he had his mother, who had a house worth, I think at the time, $100,000, had put this gentleman's name, her son's name on the property as a joint owner. And the son knew about this. And so basically he had an undivided interest in a $100,000 asset. So when he went to move to dismiss the case, obviously the trustee, I guess, got wind of it somehow, maybe from a creditor. The trustee had notified him, I would oppose any kind of dismissal. So again, he came to me, and I talked to the trustee, and the trustee said, look, he's filed bankruptcy. That is an asset that is now property of the bankruptcy estate. I'm going to go ahead and liquidate it for the benefit of creditors unless you want to make me an offer. So in this case, what we ended up doing was we made the trustee an offer, I think, of $45,000, which represented approximately half interest in it. Trustee could have been more demanding, but he accepted that. And my client had to get his mother to take a home equity loan and borrow $45,000 of money on this property that was owned free and clear to buy out the trustee. That was a very expensive lesson. So the point is that when you have a Chapter 7 case, you cannot just dismiss it, especially and in particular if you have any sort of non-exempt asset that the trustee could go after. Now, if you don't have any assets the trustee can go after, probably nobody's going to oppose it, but the trustee, I will tell you, is going to be very suspicious about anybody who wants to dismiss a case. So realize when you go into a bankruptcy, this is another reason why you never want to file bankruptcy without the guidance of a lawyer. All kind of bad stuff can happen, but especially in Chapter 7. Chapter 13, you can generally dismiss it voluntarily, although there's some exceptions to that too. Chapter 7, you cannot, and if you do want to go try to dismiss it, you're going to be asked a lot of questions, and you're going to be, your asset picture is going to be studied very carefully. You're going to be required to make a full disclosure so that the court is convinced you're not trying to hide something or play any kind of games with it. So that is the answer to that question about dismissing a case. I hope this has been helpful to you. Any questions about Chapter 7, about consumer bankruptcy in general, feel free to call me. Again, Jonathan Ginsberg here, and I hope to hear from you soon.